role. Guyana's representatives were the former Chief Justice of British Guyana, Sir Donald Jackson, and the Solicitor General of Guyana, Dr. Mohammed Shahabuddin, who of course later served as a judge at this court and then at the ICTY. Venezuela's two representatives were no less illustrious. Luis Loreto, who would serve as a Justice of the Supreme Court of Venezuela, and Dr. Gonzalo Garcia Bustillos, who would become Venezuela's ambassador to Cuba and to the Organization of American States, and then Minister of the General Secretariat of the Presidency of Venezuela. Between 1966 and 1970, the Commission held 16 meetings, and the Commissioners published biannual reports. Yet the work yielded no progress towards a practical solution. This was largely due to the parties' inability to agree on the Commission's mandate. Guyana focused on Venezuela's contention of nullity of the arbitral award, whereas Venezuela addressed how much of Guyana's Essequibo territory should be relinquished to it, or subjected to a program of what it called joint development. As Dr. Shahabuddin put it, the process failed because, in his words, of Venezuela's deliberate refusal to recognize the plain meaning of Article 1 of the Geneva Agreement. And this made it impossible to grapple with the main burden of the task entrusted to the Mixed Commission. Now, the Venezuelan commissioners fully understood what failure entailed, and in 1966 they explicitly acknowledged that if the Commission was unable to resolve the controversy, then, and you'll find the words at tab 13 of your folders, and I quote, "The juridical examination of the question would, if necessary, be proceeded with in time by some international tribunal in accordance with Article 4 of the Geneva Agreement." End of quote. The Commission's progress was further impeded by Venezuela's open hostility towards Guyana. In October 1966, for example, Venezuelan armed forces invaded and occupied Guyana's half of Ankoko Island, and they then constructed military installations and even an airfield. Guyana protested against this flagrant breach of its sovereignty. Within 2 years of the invasion of Ankoko Island, the president of Venezuela, Raúl Leoni, issued a decree purporting to annex Guyana's territorial sea up to the mouth of the Essequibo River. Guyana again protested. To this day, still now, Ankoko Island remains under unlawful Venezuelan occupation, and Venezuela claims the maritime area off the coast of Guyana as its own. In 1970, with the failure of the Mixed Commission to reach agreement, Article 4, Paragraph 1 of the Geneva Agreement became applicable. You'll find it at tab 12. This required the governments of Guyana and Venezuela to, and I quote, "without delay, choose one of the means of peaceful settlement provided in Article 33 of the Charter of the United Nations." End of quote. Guyana and Venezuela were not able to reach agreement. In view of the impasse, the Prime Minister of Trinidad and Tobago, Dr. Eric Williams, moved to a moratorium on the dispute resolution process under Article 4 of the Geneva Agreement. Guyana welcomed the initiative, given Venezuela's escalating threats, which undermined Guyana's stability, development, and territorial integrity. On the 18th of June 1970, the parties concluded the Protocol of Port of Spain. Venezuela and Guyana agreed to suspend the operation of Article 4 for an initial term of 12 years. During that period, they agreed to, and I quote, explore all possibilities of better understanding between them and their peoples. End of quote. 4 days after the protocol entered into force, Venezuela acknowledged the lack of any progress at the Mixed Commission and what it called the sad but unquestionable deterioration in relations between Venezuela and Guyana. An official Venezuelan memorandum described the Protocol of Port of Spain as a happy outcome and a compromise that was closer to Venezuela's original proposal than that of Guyana. By Article 2 of the Protocol of Port of Spain, Guyana and Venezuela agreed to refrain from making assertions of sovereignty over the territory of the other while the protocol was in force. Nevertheless, in November 1981, Venezuela did reassert its claims to the Essequibo territory and sought to deter international investment in Guyana's Essequibo region. Following Venezuela's formal notice of termination, on June the 18th, 1982, the Protocol of Port of Spain expired. As Venezuela's foreign minister explained, this allowed, and I quote, the full reactivation of the procedures indicated in the Geneva Agreement. End of quote. So we move to Article 3 of the Protocol, which provided that upon its expiry, the functioning of Article 4 of the Geneva Agreement shall be resumed at the point at which it has been suspended. In mid-1982, Guyana and Venezuela were therefore once more required by Article 4.1 of the Geneva Agreement to choose one of the means of peaceful settlement provided in Article 33. The parties were not able to reach agreement. For its part, Guyana proposed judicial settlement, but Venezuela insisted on diplomatic negotiations. With no consensus, Article 4, Paragraph 2 required the parties to refer the decision as to the means of settlement to an appropriate international organ upon which they both agree. Guyana proposed 3 possible bodies as the appropriate international organ: the International Court of Justice, the UN General Assembly, or the UN Security Council. Venezuela rejected all 3 bodies. In September 1982, it explained, as you will see at tab 14, that Venezuela has become convinced that the most appropriate international organ to choose a means of settlement is the Secretary-General of the United Nations, which organ accepted this responsibility and whose role has been expressly agreed upon by the parties in the text itself of the Geneva Agreement. 1 month later, Venezuela reiterated, as you will see at tab 15, that in order to comply with the provisions of Article 4, Paragraph 2 of the Geneva Agreement, Venezuela wishes to reaffirm its conviction that it would be most practical and appropriate to entrust the task of choosing the means of settlement directly to the Secretary-General. Since it is evident that no agreement exists between the parties in respect of the choice of an international organ to fulfill the functions provided for it in Article 4, Paragraph 2, it is obvious that this function now becomes the responsibility of the Secretary-General of the United Nations. And so, in the absence of agreement, Article 4, Paragraph 2 required the parties to refer the decision to the Secretary-General. And this was clearly understood by both parties. On 31st of March 1983, Secretary-General Javier Pérez de Cuellar, whose memory, Mr. President, you so graciously evoked, confirmed that both governments had asked him to act under Article 4, Paragraph 2, and that he would inform the parties on how he would discharge that responsibility. And so, in August 1983, the Secretary-General, Pérez de Cuellar, dispatched the Under-Secretary-General for Special Political Affairs, Diego Cordovez, to visit the two countries. During the meetings, both parties reaffirmed their readiness to cooperate fully with the Secretary-General in the discharge of his responsibility under the Geneva Agreement. They also provided a wide range of information which was, and I quote, most carefully studied, end of quote, to ensure that the choice of the means of settlement will facilitate a definitive and durable resolution of the controversy. For 5 years, between 1984 and 1989, the parties engaged in regular meetings and discussions at the diplomatic and ministerial levels, as Mr. Cordovez assisted the Secretary-General under Article 4, Paragraph 2. In early 1990, the Secretary-General, Mr. Pérez de Cuellar, decided that a good officer's process would be used as the first means of settlement, to be conducted by his personal representative. Now, you will have noted that a good officer's process is not explicitly listed in Article 33 of the United Nations Charter. Nevertheless, as Venezuela expressly acknowledges in its recent memorandum in respect of these proceedings, it does fall under the residual category of other peaceful means of dispute settlement. And thus, as Venezuela now recognizes, the Secretary-General did not begin with the means in the order they are set out in Article 33, namely negotiation, inquiry, mediation, conciliation, etc., etc. Yet it is noteworthy that Venezuela did not object to the Secretary-General's choice of good officers on that basis, or indeed on any other basis. To the contrary, Venezuela welcomed the Secretary-General's decision. So it is common ground that, in taking his decision, the Secretary-General acted in full compliance with the powers and responsibility conferred upon him by the parties under Article 4, Paragraph 2 of the Geneva Agreement. Venezuela accepted the choice he took, including its reasons, its rationale, and its basis under the agreement. From 1990 onwards, successive Secretaries-General appointed a series of distinguished personal representatives to conduct the good officers process. The first was Professor Sir Alistair McIntyre of Grenada, the former Secretary-General of CARICOM, a renowned academic and statesman. He served until 1999, when he was succeeded by Oliver Jackman of Barbados, a distinguished jurist, diplomat, and a judge of the Inter-American Court of Human Rights, who served for 8 years until his death in 2007. Professor Norman Jervin of Jamaica, the former Secretary-General of the Association of Caribbean States, served as the third personal representative from 2010 until his death in 2014. Over 24 years, from 1990 to 2014, the parties and successive personal representatives and Secretaries-General engaged in intensive efforts to reach a satisfactory resolution of the controversy through the good offices process. Those endeavours included annual meetings between the parties' foreign ministers and the Secretary-General himself. Throughout this entire period, Guyana and Venezuela repeatedly reaffirmed their commitment to the process mandated by the Geneva Agreement. In 1993, for example, the parties issued a joint statement, you'll see it at tab 16 of your folders, in which they reiterated their deep and unswerving commitment to the peaceful resolution of issues within the framework of the 1966 Geneva Agreement. In 1998, 5 years later, they issued a further joint statement. You will find it at tab 17 to explain